the situation with is it Harrison? What's his last name, Kim? I
Yeah,
don't know if
his name is Harrison Floyd, and
yeah.
he is one of the defendants, one of the 18 co-defendants in the Georgia state case for election interference. And apparently he went online, made some really inflammatory social media posts. The judge says that is an intentional and flagrant violation, and they say they're now the judge is hearing arguments about possibly revoking Harrison Floyd's bond. And it's just interesting how Harrison Floyd, one of the 18 co-defendants, can get busted for a social media post, but Trump keeps going on Truth Social and saying the most horrible things, and can stand on the courthouse steps and yap, yap, yappity yap, and nothing happens. Maybe a $10,000 fine. That's it.
Well, normally a defendant is required to obey all laws, right? And so people get in trouble when they make an inflammatory threat like that. Trump has tried to walk what courts consider a fine line. Whether he stepped over that line, apparently no court has been willing to say so far that he's actually broken the law or committed a criminal violation, what we call an actual threat. The First Amendment has limits, and you can't yell fire in a crowded theater. You can't defame somebody. You can't blackmail or extort somebody and say, oh, well, it was just speech. I was merely speaking words. And you can't make what's called an actual threat. Now, Trump, he says these things like the famous King of England, right? He says, will no one rid me of this meddlesome priest? And of course, in history, soon after the Archbishop of Canterbury was killed. But Trump tries to make subtle comments like that. And one of the things they're dealing with in the gag order that just got argued in the D.C. Circuit Court of Appeals yesterday in a very long and interesting argument that was not televised, but it was streamed on radio, streamed over so you could hear it. They asked that question, that they're going to put some gag order, it looks like, in place. It will be more narrow than the one that the district judge Chutkan put in place and that's been suspended during this expedited appeal period. And that debate of what that's going to be has been really fascinating. And then if he violates that order, he would be in contempt of court. Just one more note, in federal court, normally, if you violate a gag order or you're otherwise in contempt of court, you get a separate indictment and a separate trial. They normally don't handle that. And of course, that would be hugely controversial because that would be a new trial, a new fifth trial for Trump, right? And so he's going to try to walk up to that line. But just guessing what it's going to be, Mark, it looks like they're going to say you can't make inflammatory threats to witnesses short of a criminal violation. You can't break the law. That's clear right now. And that's what this fellow that you're talking about apparently is being looked at right now for simply breaking the law while he was out on bail. That's also state court. So there would be, you can't break the law if you're on bail in federal court. You can't make a true threat. But there'll be something less than that that Trump can't do, I believe the Court of Appeals will say, and that is to make inflammatory things that don't rise to the level, but that are things like, will no one rid me of this meddlesome priest? And
Sure.
They won't be true threats, but they'll be the way that he talks, and they'll try to block that because there is a real interest that balances against the First Amendment, which is that there be proper trials and that there not be juror and witness intimidation.
No, you stated so well, but you also allow for what I think is an interpretive aspect to this. When you, even in the likely ruling, the more restrictive ruling that you've laid out, that gag order allows for interpretation. And I guess that's what the court is there for.
Well, there are two possibilities, I think. The Court of Appeals in D.C. will make a more narrow order and they'll put it in place. They'll say, thou shalt not do this, that, and the other thing. That will be fewer thou shalt nots than the district judge said. And people believe that that will not go up to the U.S. Supreme Court. If it looks like that's what they're going to do, those are three appellate judges appointed, selected by Democrats. And so I think that the Supreme Court will think, you know what, this involves Trump. It's so polemic. Let's stay away from this. Let's not review the order that the appeals court, three Democrats sitting on it, comes up with. But then what's going to happen, Mark, is that there'll be there'll be a back and forth with the district court, because something will happen. Trump will make a posting, and the special prosecutor will go in and say, hey, wait a second, we think that violates the order, or it's something out of the blue. So they say, we need a new order. We didn't really think that Trump was going to sink to that level. But look at this, Your Honor. You need to make an order that stops him from doing this in the future. So I don't think this will be the last word. I think it will be on this particular gag order, but I don't think it will be the last word. I think people should get ready for the fact that they'll go back to court. There'll be more. This will be an ongoing issue. And remember, the judge is going to try to get this case to trial by March, before the election. And people have said it would change my vote if a jury of his peers found Trump guilty. And so I think that's what the system is heading toward. Trump may protest, but I think unless the Court of Appeals intervenes, this gag order litigation will not delay the trial. I think the only thing that might delay the trial is his so-called presidential immunity, which I think is not a viable claim at all, but there's no precedent for it. So if the Supreme Court wanted to give Trump a delay, I think the way that that would happen, Mark, is that they would take this presidential immunity claim that Trump's making, and that the district judge, I believe, will certainly deny, and I think she'll deny it soon. They'll take it up to the U.S. Supreme Court after they take it to the Court of Appeals, and the U.S. Supreme Court will say, there's no precedent. We need to think about this. And while we're thinking about it, the trial is stayed. That way, the Supreme Court could be viewed as not having kicked it past the election, but they would have, in fact, kicked it beyond the election. Remember how they kicked his wow. tax returns down the road? Remember that? For a couple of years, a couple of visits to the Supreme Court, years and years went by. And finally, at the very end of his term, the Congress finally got his tax returns, which showed that he paid so very, very little. And I think in 1 year, remember, Mark, it turned out he was the biggest loser. He lost more money than any other taxpayer in American history, and they want to vault him to the presidency because he's such a business genius. Go figure.
Well, David, that is a great drill down on these gag orders and the way the Supreme Court can, in a way, do nothing but and meaning they don't rule on it, but they put it aside, and by putting it aside, it stops the clock and it helps their benefactor. The voting rights case is the other thing I wanted to mention to you. This seems like a big deal. I wonder if you could explain, because the legal part of this is interesting. It essentially, I think, prevents a lot of these organizations that are concerned with suing on behalf of voters to bring voting rights rulings to pass. It prevents them from those suits.
Okay. Mark, it got very hot in my law office, so if you don't mind.
Please. Yeah, okay, go ahead.
Yes, this is a case from the Eighth Circuit Court of Appeals. The United States is divided up into about a dozen federal courts of appeal, and they sit geographically. This one goes from Arkansas up through the Dakotas, is right smack there in the middle of the country. So this particular case is from Arkansas, and the Eighth Circuit there said, and I think these are Trump-appointed judges who said this, all of them I think are Trump-appointed. They said, you know what? There's no private cause of action under the Voting Rights Act. I think that's remarkable. I think that will go to the U.S. Supreme Court. I know that they have 4 votes. Roberts, I believe, will join in saying this is not the law. There is a private right of action under the Voting Rights Act. And I think that probably Kavanaugh or Barrett will go with those 4. And so I don't think this is going to ultimately be good law. But if it's good law, to me, it completely undercuts the Voting Rights Act. The idea is that these rights to have fair voting, to not have, discriminatory practices. This is a major achievement of the civil rights movement back in the 60s. Before that, there were poll taxes. If you showed up and you were black and you wanted to vote in the southern state, they said, well, you haven't paid your poll tax this year. If you didn't have the money on you, you weren't allowed to vote. Of course, the gerrymandering, which continues on. But there were so many Jim Crow restrictions on voting that the Voting Rights Act was absolutely called for. It was a great piece of legislation. Now, it was cut back in the famous Shelby County case. And in that case, Chief Justice Roberts was one of the ones who actually cut back the enforcement of it. And I mean, I think it's interesting to know there used to be what was called pre-clearance, which meant that before one of these 7 or 8 southern states that had a history of denying African Americans their voting rights, before they changed some aspect of voting, they had to get pre-clearance. They had to go to the Department of Justice and say, we're planning to do this. We're planning to do something that's going to end up making mainly Black people wait in lines for 4 hours to vote. And then the Department of Justice would say, well, no, you can't do that because that's the effect it's going to have. So no, you can't make that change. But Roberts, along with some others, said, the South has changed so much. We don't really have these problems with poll taxes anymore. It's all good. It's all cured down there. And so it was remarkable because Congress kept voting to extend the Voting Rights Act. Republicans, were in favor of these Voting Rights Act protections, Mark. And yet here the Supreme Court said, no, we don't need it anymore. And people said, what, you guys are political scientists? Why don't you rule on legal cases? That's what you know about. Well, you're going to decide the political science. You're going to decide how much the South has changed in these states. But they did. In doing that, Mark, Chief Justice Roberts says, but look, you could still bring a private cause of action under the Voting Rights Act if the Department of Justice doesn't do anything. Let's say a Republican is in there who likes the fact that this change in the voting bill helps Republicans and doesn't do anything about it. Okay. And so the pre-clearance route is not there, but Alabama goes and changes its law. Georgia goes and changes its law in a way that you think discriminates against Black people or diminishes their voting rights. Well, you can always bring a private cause of action, Chief Justice Roberts said. And that's why I think it's very clear that having said my vote in Shelby County is okay, even though I'm getting rid of the pre-clearance for the majority, it's all okay because after all, private citizens, private parties can still bring these Voting Rights Act cases. Now, with the Eighth Circuit saying no, private parties cannot bring these voting rights cases, I think that Roberts will not go for that. And I think that he'll get either Kavanaugh or Barrett to go with him, and they will save this private right of action. But what it means is these advocacy groups, Mark, and they often are the ones bringing suit, the advocacy groups like this Arkansas advocacy group on behalf of voting rights, that was the plaintiff here. They were thrown out of court. As things stand right now, they were thrown out of court, not because Arkansas wasn't discriminating, not because they weren't diminishing the votes of Black people in an illegal way, but because they didn't have standing. They didn't have a right, supposedly, under the statute to complain about it. And let me just mention one more thing about it. What's interesting is that they kept renewing the Voting Rights Act from 1965 on. As I said, even W and the Republicans voted to extend the Voting Rights Act. That was the old Republican Party. That was not the Trump Republican Party. But since when they did that, they issued a committee report. Both the House, and the Senate said, you know what? It is our intention to allow private groups like advocacy groups to bring cases in federal court in support of Voting Rights Act and to complain about a diminution of minorities' voting rights and to get relief in court. That's our intention. They apparently didn't expressly write that into the statute, but they made clear in extending the statute that that was the intent of both the House and the Senate. So I think that's enough legislative history. I think with Roberts on their side, I think the Eighth Circuit decision will not ultimately stand. But it sure is scary. The only one who can sue then is the Department of Justice Civil Rights Division. Now you might say, why didn't Biden triple the number of attorneys in the Civil Rights Division? And they could bring 3 times as many suits as they do currently. But apparently that wasn't a priority, or Manchin wouldn't vote for it, or whatever the problem was. When they had all the houses of Congress, they apparently did not pass a bill to have an awful lot more civil rights division attorneys in the Department of Justice. After a while, there are just so many. They can just bring so many cases. The states that are under scrutiny fight back really hard. And so they could only bring the cases that they could bring. And you worry that if Trump, let's say, is reelected, this will not be a big priority, to understate it, to increase the voting rights of minorities, even though they have a right to vote, and even though it's illegal to suppress their vote, that the Department of Justice Civil Rights Division under Trump or under whoever the Republican might be after Biden, if that's what fate holds, they won't bring those kind of suits, or they won't bring them aggressively, and then the advocacy groups will be out of court. But I don't think the Eighth Circuit decision is going to stand, scary as it is right now.
This country just does this, everything to choke off the people's voice in every which way. And that's why this Voting Rights Act is so important. Oh my God, the Voting Rights Act. What did Martin Luther King also march about beside desegregation? Was it all for nothing, says Vilma. Yeah, I mean, it's an essential right, the right to vote, and that's the people's voice. And it can be blunted in so many ways. We've talked about it before. It can be blunted based, you can suppress the vote just by removing a lot of polling places. That's what they've done in Texas, and then you do these other things and then prevent the public and public interest groups from bringing suit. By the way, it's true, David, polemic is a ding word, and so is diminution. Thank you. Now, I want to ask you about a statute of limitations thing that's a little far afield from what we're talking about, but it's just so weird. This just happened. The Bill Cosby accuser, okay, the one who brought the first case, she has now filed a new lawsuit under the New York survivors law. They've changed the statute of limitations, I believe, in New York, such that sexual assault doesn't have that tight time frame of the statute of limitations. Can you speak to this whole statute of limitations thing? I realized as I read it, maybe I don't understand statute of limitations. Some things have statute of limitations, some things don't. I know, there's no statute of limitations on murder and some other things. I wonder if you could just help me recalibrate.
There are some technical arguments about an extension of the statute of limitations after it's run, and I don't want to get into all of that. But let's assume for a second that this is lawful, and that the courts are not going to strike down any of these convictions because they find that the statute is defective because this extension of time is not proper under people's rights. But let's assume that it is. So legislatures, after the Me Too movement especially, and the New York legislature decided to say, you know what, you can bring these very old claims during this 1 year window. And we're about a week, I think, away from the closing of the 1 year window. So for the attorneys who want to bring them on behalf of claimants, this is about the last week. And so that's why we're seeing a flurry of them before the window closes on this 1 year statute of limitations. There are two arguments why a statute of limitations for something other than, murder or a case like that are a good idea. And the arguments for a statute of limitations, which are statutes, legislatures pass them. They could have not passed them, but they passed them all over the country. They passed them pretty much all over the world. I mean, there's certainly a feature of Anglo-American jurisprudence. And the idea, one, is repose, that even if you've done something wrong, again, murder, you don't get any repose. But the idea is that after a while, you have repose. It's over. You've been subject to the statute of limitations for a period of time, and now you have some repose. These legislatures decided that for these kinds of sex crimes, there should be no repose. The other argument is the difficulty of proving them, just the evidentiary thing. The idea is that you're going to get a lot of very unfair verdicts if you don't have a statute of limitations. And of course, I believe this case with Cosby goes back decades. I mean, literally decades. And so there's, some people say, well, wait a second, if you remember it, you remember it. And if you, something that traumatic, Cosby ought to remember it and ought to be able to defend himself. But there certainly is the argument, Mark, that it's just so long after it happened, you can't get evidence anymore. You can't get records. If it comes down to a he said, she said, it's still I think some of them are criminal cases. The civil cases are a preponderance of the evidence. So if it's a preponderance of the evidence and it's a 50-year-old claim and someone says it happened and the civil defendant says it didn't happen and the jury believes the civil plaintiff a little bit more than the defendant, like believes her a little bit more than they believe Cosby, they're going to return an award. And of course, once there's an award against a very rich person, it can be a very large award.
And I suppose that's one of the reasons she's bringing it to as a cold slap in the face to him. I mean, she was violated, and she feels the need to, keep rattling his cage.
These are allegations, Mark. These are allegations. Someone can make an allegation, right? That she's making an allegation in court.
But
And,
the reason I say it, the reason I state it sort of not as an allegation, David, wasn't he found liable in the case that they threw out with? You understand what
But I believe that was to other people, and I could be wrong on that. But if you know that he was found, that the allegation by her was upheld somewhere. But I think that she sued in Massachusetts or something. There's some backstory to this whole thing, and it may be that the allegation has been shown. I'm just saying, as a general matter, even though it's a very serious offense, still you have to, I think, give the benefit of the doubt always. Obviously, in a criminal case, you're presumed innocent, and I think it's fair to say in a civil case, you're certainly presumed not liable until somebody proves in court, that you are liable.
Fair enough. She was one, they suggest, among the first accusers to make these accusations, to speak publicly about Cosby. She met him when she was 19 and just breaking into comedy. She did sue in Massachusetts. Again, great knowledge from David Katz. And she was among 7 women who filed defamation claims after Cosby branded them liars. This is a new lawsuit. So, yeah, you're right. I mean, you speak it's no wonder you're a defense attorney now. You speak so well, to be fair to someone who probably, let's face it, got away with a lot of stuff. I'll say that. You don't have to say it. And Cosby was not a good guy when it came to this stuff. David, I do want to tell you, we're so grateful. We have so much fun with your conversations. They're so enlightening, and they have a dynamic, an intellectual dynamic and a factual dynamic that just adds another layer to the show. And I'm so grateful. And thank you for moving this time this week so we could share some time with you. And we give thanks for you this year. Thank you, my friend.
Mark, if I could just say for a moment, I really enjoyed being with you and Kim. And, the irony was that when you had that wonderful radio show of yours, I was never on the radio show. But after the demise of the station that shall not be named, you were gracious enough to invite me on. And the first time I was ever on your show was, I believe you already had the podcast. And then I was on with Pat Thurston quite a bit. And I'm on with her on KCBS from time to time. They ought to give her more time. If you're listening out there, you ought to give Pat Thurston more time, because we cover some of these issues, but we have about 6 minutes on the KCBS in the Bay Area. But with you, we can really, drill down on them, and we get to cover some of the great legal events of the day. You know how much I enjoy commenting on the U.S. Supreme Court. I followed it ever since I was in law school. And I try to sort of tell it like it is, Mark, like I say, not right, not left, just right, not wrong. And my attitude, Mark, is if you came to my law office and you said to me, it really matters to me to know how this case is going to come out. Would you analyze this case and tell me, how do you think it's going to come out? I try to tell your listeners and viewers how I think the case is going to come out. Somebody wrote one time and they said, it's so great and so depressing to hear David Katz, because some of the cases like, Dobbs, some of the cases like this 8th Circuit case, we seem to have one about every other week that, I'm grinding my teeth, but I'm telling the people what the two sides of the argument were and how it came out, or how I think the appeal of it, or how some future trial will come out.
The battle in the courts may determine the future of this country in many ways, certainly the character of the country. So you couldn't be more front and center. Well,
Happy
you're right.
Thanksgiving to you guys.
Yeah, thank you. We grabbed you. I saw it as one of the great opportunities in that awfulness that was that radio station going away, was that you became a free agent and that I could scoop you up. So really a lot of fun. I see something here. I'll share it with you. I can't quite read it without my credibility. Guys, Katz is one good thing that came out of the end of the radio show. Yeah, BW Rock is right. So thanks, David Katz.
Had a mind meld with you, Mark. They had the exact same thought about
exactly the same thought.
Time. That's the mind meld.
Katzadamus. See you, David Katz. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.